Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything.
You're my everything.
How can I express my gratitude?
How can I express my gratitude
for all the many things,
you've
Father,
done
you
for
done
me?
for me, yeah.
Words are not enough to say thank you.
Say, Lord, you are,
Lord,
you
you're
are.
my everything.
Say, I call you Jireh.
Lord, my provider.
I call you Nisi. You are my banner. I call you Rapha. Hey.
You are my healer.
Say, Lord, you are.
Lord, you're my everything.
I call you Jireh.
Lord, my provider.
I call you Nisi. You are my banner. I call you Rapha.
You are my healer.
Say, Lord, you are. You are.
My everything.
Uya matinyana. Uya matinyana. Uya matinyana. Oh, uya matinyana. Yeah, so uya.
Moya matinina. Moya matinina.
Yeah.
Moya matinina.
Oh, uya matinyana. Say, I call you Jireh, say.
I call you
Yeah.
Lord, my provider.
I call you Nisi. You are my banner. I call you Rapha. Hey.
You are my healer.
Say, Lord, you are my everything. Yeah. Are you ready, everybody? All right, listen. William Miguel, come here. 1, 2, 3.
Oya mi guapo, que la mamá me viene sola.
Yeah.
My life is in your hands. I can live without you.
I can breathe without you, say.
I can breathe without you.
I can move without you, Lord.
I can move without you.
Hey, who am I without you?
Who am I without you?
Say, I can live without you, yeah.
I can live without you.
I can breathe without you, Lord.
I can breathe without you.
I can move without you, yeah.
I can move without you.
Who am I? Who am I? Who am I? Who am I? Hey, who am I thinking now?
Oya matinina. Oya matinina.
Oh, so who yeah?
Oya matinina.
Who yeah?
Oya matinina.
So who yeah?
Oya matinina.
Oh,
Oya matinina.
Martina, me oh.
Hello, and hello again. Good afternoon, and a warm welcome to another edition of the Community and the Law, brought to you live on BWTV and sponsored by BWF Solicitors. This afternoon, we're looking at how to use judicial review to reverse a visa refusal here in the UK. Lawyer Charles Osma is ready and on hand to do that. So let's get into it together. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, are trusted of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community on the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, and I'm so delighted to have you round for another edition of the Community and the Law. My name is Oreku Frimpong. Thank you so very much for being here. And I know definitely that what we're going to learn and go through and even discuss this afternoon is going to be of massive benefit to all of you. Judicial review. Last week, we looked at some of the steps you need to take to remedy that situation where your UK visa is refused. We looked at the admin review. We looked at the appeals and the judicial review. Now, this afternoon, I want us to critically and closely look at what judicial review itself is and how we're going to use that opportunity to reverse a UK visa refusal. And I'm delighted to say that a friend, a brother from BWF Solicitors is here with us. Lawyer Charles Asma is here with us and he's going to lead us in that discussion this afternoon. So get your notepads ready, tell a friend to tell a friend. And when you have logged on to BWF Solicitors on Facebook, BWF Solicitors on YouTube, BWTV on Facebook, BWTV on YouTube, you would announce your presence and also like the page, share, and subscribe to the channel if you are new here. We are going to also help you come up to date with the pieces of information that have come from the Home Office and, of course, some updates here in the UK. We'll also be looking at Ghana as a country who's celebrating its month, this month, March 2025. 68 years of independence. We're looking at some of the things that Ghana has, in particular and peculiar to the legal situation. We'll be looking at those symbols and what they are doing in the realm of legal matters and how they kindly and very prominently represent Ghana. So, if you are ready with us, let's look at our nugget for the week. Do you know that making a new application while your administrative review is pending will not protect your lawful residence? That's a big question. And let's see the explanation that's there. We're taking it from Appendix Administrative Review AR 4.4. And it says when you make an in time application, but it is refused with a right of appeal or administrative review, your lawful residence will continue during the waiting period for a decision because it will be pending. However, a fresh application will cancel the protection given by the administrative review because it is no longer pending and is treated as withdrawn. So what it's saying is that, yes, you've made an application, it's in time. You don't wait for the deadline to be over. You've made an application, but it's refused, so to speak. And you say, okay, well, I haven't given the right of appeal, so I'm going to go through that route. Or you have decided to file for an administrative review, and they say, we haven't made a decision, it's pending. What it means is that your stay will not, or your lawful residence will not be cancelled. But if you decide to say, okay, well, that application I made, I don't think was correct, so I'm going to make a new one. What will happen is that they will see as you would have withdrawn the previous application and you put in a new one. So if there was any protection of the previous one, it would not cover you. So be aware that making a new application while your administrative review is pending, you will not be protected under the law and your lawful residence will not be valid. So take note of that. Thank you very much. Now, let's look at Ella Champon saying thank you to BWF Solicitors. Ella Champon says, I want to take a moment to express my heartfelt gratitude for your exceptional guidance and expertise throughout my citizenship application process. Your professionalism, knowledge, and dedication were instrumental in achieving this milestone. Champon continues to say, BWF Solicitors, your efforts made a significant impact on my life, and I'm forever grateful. Please know that I highly recommend your services to anyone seeking expert legal counsel. Thank you again for your outstanding support and congratulations on a successful application. Well, Champo, thank you very much. BWF Solicitors is also very, very appreciative of you. They happy that you trusted them and you got them to deal with your situation for you. So tell people, tell others that BWF Solicitors has done that great thing for you, and you would want to have them also taste the same level of success you have had. So yeah, Achampo, thank you very much. Client review, bring it on. Go to the BWF Solicitors Facebook, YouTube page, and all the other social media platforms and leave the comments there. You can also go to Google and do the review there as well. It will be picked up. Or you go to BWF Solicitors website, www.bwfsolicitors.com, and definitely BWF Solicitors will pick that one up. If you want to look at what they have, visit them. If you want to experience what they do, visit them. They are on the fourth floor of the other house, 214 to 218 Tottenham High Road, Seven Sisters, North London. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. So call them, book an appointment on 0208 493 7340, 0208 493 7340. In Ghana, those of you in Ghana, you want to make use of the service of BWF Solicitors, 055 589 5959, 055 589 5959. In emergency situations and at all times, send a text, WhatsApp message, or call +44 77 12 76 1884, +44 77 1276 1884. BWF Solicitors helps us with all the bits and pieces of legal education, and this afternoon we're looking at the community and the law, and that's where you are on now. Thank you very much. Now, freedom, justice, and protection, they are the cross symbols in law. Let me get you into some Ghanaian culture. Justice, freedom, and protection, Adinkra symbols in law is what we're looking at. Now, what do you see on your screen now is known as a bang. A bang literally means, in Ghanaian language, it means fence. And it talks about what it is that you can get to protect yourself and stay in a realm of safety. So a bang is a symbol of safety and protection. What does it mean? It represents wisdom, knowledge, and the ability to learn and apply lessons. It means wisdom, knowledge, and the ability to learn and apply lessons. What is the legal relevance here? A bind reflects the role of legal wisdom. It reflects interpretation of laws and the importance of careful decision making in justice. So when you are in the Ghanaian realm and you see the symbol that is representing a fence, then it means that we're reflecting on the role of legal wisdom, interpretation of laws, and the importance of careful decision making in justice. Let's pick another one. This one says Abai, that is fortress, symbol of strength and authority. It represents power, governance, and strong leadership. What's the legal relevance here? This symbol symbolizes government institutions, legal authority, and the enforcement of laws. So the fortress represents government institutions, legal authority, and the enforcement of law in the Ghanaian context. Let's look at another one. Fahudie. Fahudie means freedom, symbol of freedom and responsibility. Independence, self-determination, this is what is used to represent that concept in the Ghanaian parlance. The legal relevance here, it represents human rights, it represents legal emancipation and the responsibility that comes with freedom. So if you see this symbol on your screen, it's freedom, symbol of freedom and responsibility. These are some of the symbols we have in the Ghanaian legal realm that has some relevance in the legal world, I should say. EPA, and this is the handcuffs, symbol of law and justice. So EPA, those of you who may be Ghanaian and you don't even know what EPA means, it is handcuffs. and it symbolizes law and justice, the enforcement of laws, the justice system, and the consequences of unlawful actions. So when you see this Adinkra symbol, it is the handcuff or EPA, a symbol of law and justice. The next one here is Mati Messier. Mati Messier. I've heard and kept it. It symbolizes wisdom and prudence. Um, Sometimes in the account parlance, it says "Openi die mati mante." This is the symbol that represents that yes, an elderly person who is very prudent would behave as if, well, I've heard something, you are gossiping behind the people, you're susceping on them and all that. I've heard you, but I've decided not to hear, and then I'll take my time. I'll be very prudent in judging the matter. So this one, Matimesi, represents wisdom, knowledge, and the ability to learn and apply lessons. It reflects the role of legal wisdom, interpretation of laws, and the importance of careful decision making in justice. So you see, when it comes to the law fraternity, they don't just out of the blue, in a rush, make decisions. They scrutinize, they analyze, and make sure that they make the best decisions and arguments out of every situation. So, yeah, if you want a copy of these and you want to enhance your knowledge of that, you can send an email to BWF Solicitors, or send your comments or the desire to have these symbols on the platform, and we'll send that to you. Or you can send a text message, WhatsApp message to 07399208468, and we will send these ones to you so you can enhance your knowledge on that. Well, um, let me see if I could ask you a question here on the nugget I gave you. So I'll go back to the nugget and refresh your memory on that. And I asked the question, if you knew that making a new application while your administrative review was pending would not protect your lawful residents. And I went on to explain that when you make an in-time application but is refused with a right of appeal or administrative review, your lawful residence will continue during the waiting period for a decision because it will be pending. But if you make a fresh application, this application will cancel the protection given by the administrative review because it's no longer pending and it's retreated as withdrawn. And that's from the Appendix Administrative Review, AR 4.4. Now, having known this, let me ask you this. Kofi Kinata makes an application to remain as a spouse on the graduate route. The application was refused because the Home Office suspected the marriage was not genuine. Kofi then applied for administrative review on a case work error. So while waiting for a decision on the administrative review, Kofi receives a certificate of sponsorship from a healthcare company. The question I'm asking is, can Kofi make a switch to the certificate of sponsorship? I've given you three options. Choose one. Yes, because he's still living in the UK legally and Section 3C protects him. No, because any fresh application will bring the Section 3C protection to an end. The third one says no, because the Home Office suspects his marriage is a sham. Which one will be correct? Think about that, because I'll be asking you right at the tail end of the program. Listen, if you are here, thank you very much. Let's see a few of the ones that I have on the platform who have registered their presence. Remember, we're going to look at how to use judicial review to reverse UK visa refusal. Ade Taribo is greeting everyone. Good afternoon to you, Ade. Thank you, Tilly. Hello, lovely family. Tilly, thank you very much. We need to catch up again. Senior Nanajimai, the class is ongoing and everybody is here. Share, share, share. Well, obviously, Nanajimai has mentioned that he's here. Share and share and share. This is free legal education, and that's brought to you by BWF Solicitors Live on BW TV. Sandra Fraser, good afternoon. All, please share when you join. Thank you, Sandra. God bless you. So, well, with that, I'm going to take a quick break. And then when we come back, I will formally introduce Lawyer Charles Asma, and then we get on to the discussion on how to use judicial review to reverse a UK visa refusal.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Please. Welcome back, and thank you very much for joining us. I know you are so fired up and ready to get into that discussion. I mentioned that we're doing this courtesy BWF solicitors, who have proudly given us the platform to one, educate the community, strengthen and enhance the potential of you knowing what to do when it comes to legal matters. I have mentioned you can locate BWF solicitors on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. Call them on 0208 493 7340. Now, right from the stables of BWF solicitors, we have a brother, a friend, and a guide, lawyer Charles Asma. Uncle Charles, good afternoon.
Good afternoon, Uncle Kweku.
That tells me I have a chair sitting here with you. Well, Lawyer Charles Asma will be on screen in a moment as we try to adjust a few things here and there. Oh yeah, here he is. I thought by dint of technology, I thought I'd missed you. How are you doing, sir?
Very, very well. Good
Okay,
afternoon. The
good,
sun
good,
is
good.
shining. Hope is high. Expectations are to be met.
We thank God for all the mercies He's shown us. Yeah, we mentioned earlier on Nuggets that when people have administrative review or an appeal ongoing, they have the protection of their lawful residents being um, in place and intact. But when they decide to make a new application in other situations where they think that probably they have a better chance, that protection is withdrawn. I try to explain from my lay point of view, but help us. What makes it not have that Section 3C protection? What's going on?
Thank you very much. I'm going to keep it simplistic and analogous to our day-to-day activity. So let's take a situation where you go to a shop to buy an item. So we've bought a shirt.
Mm-hmm.
or whatever it is. Um, you've tried it and it wasn't what you wanted, so you take it back to them.
Yeah.
Ordinarily, they have to change it for you or give the money back to you, isn't it?
Yeah.
So it's been back and forth, back and forth, back and forth, and you become restless, helpless, and you feel that, you know what, I just want to buy a new thing and go on or move on. And you buy a new thing or another one, and you decide not to continue the old one again.
Mm-hmm.
And the rule is that if you buy a new one from the same shop, then you have agreed not to continue with the claim about refund. Are you with me?
Yes.
In this case, if you decide to abandon the claim and to buy a new shirt, you have agreed that this is it, isn't it?
Yes.
Because you cannot have the claim, the refund process, and the new item that you want to buy, two of them going at the same time. So the moment you buy a new one, you've agreed to abandon the existing one.
Mm-hmm.
Because the existing one was in process and you are fighting it off, the law protected you. The moment you decide to go for a new one, the law will cease to be with you. Now let's relate it to the scenario.
Okay.
You make an application for visa. At the time you applied, you had protection under 3C because you had exempt leave. Your visa had not expired before you applied.
Mm-hmm.
So all the rights for work, the right to rent, everything that you had, as if you had a valid visa, will continue to be in place up to the point a decision is made. A decision is made to refuse you, and you are challenging it, which is the refund you are seeking. You challenge it by administrative review. And the rules say that by challenging it, your rights will continue to remain.
Okay.
The moment you stop to challenge by way of making a new application, the rights that were with you through the challenge process will stop or cease.
Okay.
Now, let's compare. When the rights are with you, even though the visa has expired, the right will remain because you are challenging the refusal.
Yeah.
Bear in mind that you have already had your visa now expired, just that what is holding you is the delay and the fight you are pursuing, which is the administrative review. So the administrative review has become a link between yourself and the visa. Once the administrative review link is cut off, do you have anything to hold on to?
No, because it's no more there. They may even have closed their file.
You're not even the closing the file. It's no more there because you have chosen not to have it there.
Mm-hmm.
And how did you choose to not to have it there? You have now elected to replace the ongoing challenge with a new application.
Yeah.
Just like electing not to pursue a refund by saying that I want to buy a new shirt. So if you are buying a new shirt and the price has gone up, you pay for a new price, aren't you?
Yeah.
Exactly. They will say that at the time you bought the item, it was £5. So we'll give the new one to you for £5. No. If you are coming for a new one and it is £10 and you don't have money to buy or afford, you don't have it. Then nothing else. So the same applies to admin review. You have application refused. You are challenging the decision, and so your rights are with you. Let's say at the time because your visa was not expired or had not expired, your employer will still allow you to work. Everything else is okay. Once you put in a fresh application, all the rights you had will cease. The question is, at the time you put in the new application, did you have a visa or you just had protection? Which
You
one?
you you had protection. You didn't have the visa.
A visa. So if you don't have a visa and you put in a fresh application, that protection that existed is not a visa. So that cannot carry forward to the new application. And therefore, it has become a rule under Appendix Administrative Review, paragraph AR 4.4, that insofar as, to the extent that you are challenging the refusal, and at the time you made the application for which it was refused, you had a visa, the visa right will remain. If you stop to challenge the decision or you stop to pursue the administrative review, that right will cease. And so, if you put in a fresh application, the existing right will cease. Until the visa is issued, you do not have any right to work, to remain in the UK, or to rent or to do anything. And
Okay.
that is AR 4.4.
Well, my friend Kofi Kinata is in a situation which I am asking my cherished viewers and my friends to help me solve. Kofi makes an application to remain as a spouse on the graduate route lawyer. The application was refused because the Home Office suspected the marriage was not genuine. He applied for administrative review on a casework error. So while he was waiting for a decision on the administrative review, he received a certificate of sponsorship from a healthcare company. The question I'm asking is, can Kofi make a switch to the certificate of sponsorship? I've given three options, and I am believing that one of them is correct. Can he make a switch? One says yes because he's still living in the UK legally, and Section 3C protects him. The other one is saying no, 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 he can't because any fresh application will bring the Section 3C protection to an end. And the third one says no, because the Home Office suspects his marriage is a sham. No, I don't give you the answer now. I know you know, but don't give me now. Let me get them to think about it. At the tail end of the program, we will bring that and see who got it right. So if you have an answer, you can put it in the comment section below. You can send it to us via text 07399208 or you can even send it as WhatsApp 07399208 Lawyer, coming back to you. Last week, in fact, those who followed us on the program would have known that we mentioned three things that we can use or three steps we can take. Either we're going for administrative review, either we going for the right of appeal that will be giving us or using the judicial review. Now, the first two I will put on the back burner for now. But today I want us to look at how we can use judicial review to reverse a UK visa refusal. Is it possible even at all?
It is possible, yes, because it's worked before and it continues to work, provided you follow the rules and you have a stronger argument or challenge.
Okay. So, for probably the benefit of those who may have missed it or do not even know what judicial review is, would you kindly take us in on that? The fundamental issues. Judicial review. What are we talking about? Remember last week you mentioned you gave your situation to a referee and a higher referee. So we go in probably the highest level. Judicial review, what are we talking about there?
Thank you very much. So, anytime we talk about judicial review, it means that a matter is being left for the court to review.
Okay.
And what can a court review? A court will review any decision made by a public officer or a public body that is inconsistent with the law
Hmm.
or that is irrational, unreasonable, or perverse.
Okay.
Therefore, if the person who made that erroneous decision cannot correct it themselves, then we'll refer it to a court to review that decision with a view to reverse it or to maintain it. And because the decision is by a public body, we can have it reviewed by a court.
Okay.
Does it mean that if the decision is by a private body, we cannot have it reviewed by a court? The answer is yes. And so you see that if it is possible, then it has to be done by a public body. If it is not by a decision was not made by a public body, we cannot take it to court for judicial review. So judicial review simply means a court reviewing a decision made by a government agency or a government official on behalf of the government. Home Office is a government agency.
Mm-hmm.
Home Office case workers are government officials, and therefore their decisions represent the decisions of the Secretary of State, which is government. And so, if it is wrong in law, if it is perverse, irrational, and unreasonable, then we can refer it to court, which is the body to review that decision, provided there is no remedy already given. And this borders on constitutionality or constitutional law.
Okay.
If so, therefore, anytime a public body makes an irrational decision and there is no opportunity for the person to seek redress or remedy, a court can be um, invited to look into the decision with a view to review it.
Okay. So, in that situation, a court is invited to review the decision. Who does it? Does it because I can go to court on my own. A lawyer can go to court on my behalf. But in this situation, who does the or who initiates the judicial review? Is it the person that put in the application, or it has to be a lawyer?
Thank you very much. So first off, we look at the basics and we look at who can pursue it.
Mhm.
So we've understood that judicial review means a decision has been made by the government and it is not reasonable or in conformity with the rules. You want the court. The question is which court,
Okay.
first off. So within the spectrum of the court, we have lower courts, middle court, and upper court, so to speak. But for immigration decision purposes, if you want the court to review your decision, you have to go to the upper tribunal, which is a higher up than the lower tribunal. If it is appeal, it goes to lower tribunal, which is the immigration tribunal. But if it is a review of the decision without remedy, you have to take it to the upper tribunal. There are rules to be followed and there are timelines to be kept. So, as we said, upper tribunal is the one to review. But the question is, what type of decision needs to be reviewed? A decision that did not come with a right. So if you had a decision and you were given the right of appeal, then you know that you cannot follow the route of judicial review.
Okay.
If you were given that of administrative review, for example, Kofi Kinata's case, the scenario we had, he was given administrative review right because it's COS based, which is skilled worker. I think the initial application, the person was given opportunity to seek administrative review. That means there was no option for appeal. So the person seeks administrative review. If, for example, by the end of the review process, he's still not happy with the decision, he can move on to the court for judicial review.
Okay.
Again, if the person was not given right of appeal or right of administrative review, the only remedy or option available will be the judicial review. What sort of visa would there not be any right at all in terms of remedy? Visitors visa applications. So visitors visa applications, if you are refused, that's it. You either go to court for judicial review or you do nothing. But some other visa applications, you are given an admin review right, or you are given appeal right. So if you are given administrative review right and you don't get what you are looking for, you can move to the next step, which is judicial review. Or if you are not given any right at all, you can go for judicial review. We have a rule book, which is the Tribunal Procedural Rules for Upper Tribunal Cases, 2008. So we'll request our producer to assist us with the rule book. And because we are discussing judicial review, we have
Okay.
to refer to the relevant
Rule book.
procedure or
Okay.
the rule book. So
Okay.
the Upper Tribunal Procedural Rule Book, 2008. A producer have it available.
All right. We'll be picking that in a moment. Yes, we have that on the screen, and coming from the website legislation.gov.uk. And the one highlighted in green tells us that there have been changes to legislation. The Tribunal Procedure Rules 2008 is set up to date with all changes known to be enforced before 20th of March 2025. And there are changes that may be brought into force at a future date. Um, that's
So
the rule book that lawyer is referring us to.
good. Because we are talking about judicial review, part one is the introduction. If you look at part one, two, it says overriding objectives, just to make sure that there's fairness across board within the upper tribunal processes. And again, the court allows people to have what we call alternative dispute resolution before the matter is brought to the court for a review. And so, for judicial review purposes, there's always the first thing to do, which is administrative or what we call pre-action protocol letter or administrative review, if you're already given, for the decision maker to review its own decision or for the decision maker to reconsider by making further assessment before going further. So it says there must be alternative dispute resolution available or arbitration to before a matter is brought to the court. So it's important that the person exhaust discussions with the decision maker. We'll come to that. Number two is about general powers of the court. Of course, the courts have powers. So sometimes the court can say, we give you this opportunity, or we're not going to give you this opportunity. So the court is supposed to manage the cases. But for us, we move straight to part four, which has to do with judicial review. Part four, please scroll down, part four.
Okay, so let's scroll
Scroll down.
down to part four. We have part two on the screen. That's what Laura has explained. Um, Part four talks about judicial review proceedings in the upper tribunal, and the sections 27, 28, 28A, 29, and all that
Oh,
talks
right.
about the bits that we'll need to look at.
Good. So we can see that 27 talks about application and 28 talks about application for permission. So application of this part of transferring, so that one we are not bothered. We are interested in 28, which talks about you making application to court for judicial review. So we will look at what this rules say, and if you don't do it, what will happen?
Oh, okay.
Or if you don't
So
follow that.
I think with your permission, we can expand 28 and 28A to see
Yes.
what's in there. So applications for permission to bring judicial review proceedings. Let's scroll up a bit. Now, yes, thank you. It says a person seeking permission to bring judicial review proceedings before the upper tribunal under Section 16 of the 2007 Act must make a written application to the upper tribunal for such permission. 2 says, subject to paragraph 3, an application under paragraph 1 must be made promptly, and unless any other enactment specifies a shorter time limit, must be sent or delivered to the upper tribunal so that it is received not later than 3 months after the date of the decision, action, or omission to which the application relates. Paragraph 2 says subject to paragraph 3. So let's look at paragraph 3. It says an application for permission to bring judicial review proceedings challenging the decision of the first tier tribunal may be made later than the time required by paragraph 2 if it is made within 1 month after the date which the first tier tribunal sent A, written reasons for the decision, or B, notification that an application for the decision to be set aside has been unsuccessful, provided that the application was made in time.
Okay. Right. So if you look at 28, the key thing under 28 is the timing. How
Mhm.
long does it how many okay, how long should it take you to bring your claim for
That
the
it
court
says
to read?
within 1 month.
Try
No,
again.
you see, not later than 3 months after the decision.
Exactly.
It's the three that says if it's made within 1 month. Yeah.
Yeah. So 3 months, right?
Yes.
So you have 3 months, which is about 90 days, within which to make a claim to court for the court to review a decision. And it says no later than 3 months after the date of that decision. So the question will be, what decision are we not happy about?
Hmm.
And today's decision is a decision to refuse a visa, isn't it?
Yes.
Yeah, that's the context. A decision made by public body to refuse a decision, immigration decision or application. So in this case, that is the decision we are looking at. So there's always the need to have a context or the starting point. Let's assume that it's today, and today's date is 22nd of March
March.
2025. So the person has received a letter saying that your application has been refused and the reasons are given. This person has not been given any remedy, either administrative review or appeal. So what is there for the person? If there's no admin review or there's no appeal, what can you do?
You go to a court to help you get the decision in your favor.
Which one? The third option is the
The
one
third
we are
option,
talking.
which is the judicial review.
Good. So the person was not given right of admin and also not right of appeal. So the
Appeal.
only option is judicial review. So
Hmm.
what's the learning here? The learning here is that judicial review is given, it's available. You don't have to be told that it's there. It's there because the decision is by a public officer. And it's there also because you are not given any opportunity to fight your case. And
Yeah.
therefore, the only chance is this one.
Yeah.
And the rule under 28 of the Procedural Rules 2008 says that to do so, make sure you bring to us, we the grandpapas, to review it for you within 3 months, which is 90 days.
Hmm.
So today is your refusal date. It's a visitor's visa application. And because of that, no administrative review right, no appeal right. Because we know visitors visa, you don't get anything.
You don't get that.
So
Yes.
those who know their right will know that even though he didn't ask me to do anything, I still have judicial review to pursue.
That's right. Yeah.
Good. So 22nd, you have it. But if we look at the rules, it says that there should be alternative dispute resolution to settle the matter if it doesn't work before you come to us.
But
So
lawyer,
you,
this is a situation where they didn't give me administrative review, right? They didn't give me the right of appeal. So what am I writing back to them to say?
all right. So if you are not happy and you want to refer me to FIFA, you have to let me know.
Okay.
That's it. So we are not saying that you can't do it, but if you intend to do it, put me on notice.
Hmm.
Maybe once you tell me that you are not happy, I may change my mind.
Well,
And that's what the court is saying. So the rule, that particular rule is saying that don't rush to come. Go back. Let them listen to you. Maybe they will change their mind. So
so
before
if
you come
they
to
become
us,
recalcitrant and they don't really give you an ear, then you go back to the big bosses.
very good. Then you have a reason to come. You have a reason. So the court is saying that before you come, make sure you have a reason to come. Don't just come because you have to come. Do your homework.
Okay.
So when you go, the court will ask you, have you done your homework? Have you picked the case up with the person? Have
Hmm.
you discussed with them? Have you made them aware that you are not happy? Have you argued it out with them? And what have they done? If they come back to say that we have reviewed it and we are where we are, then you go to grandpa and say, yes, I've done everything your law tells me I should do, and they are still not yielding to my request. Then they will look into it to see whether they are right or not.
Or not.
So we've seen that the procedural rules requires that you bring the action within 90 days from the date the decision occurred. Again, it also says that before you bring the claim for us to review, you have to make sure that you don't have any remedy given to you at all.
Mhm.
So there's no admin review, there's no appeal. And it also says that before you come to us, go to them and discuss with them informally. That is called alternative dispute resolution and arbitration. Arbitration could be that you involve third parties. So some people will write to their MPs and all that for them to get involved.
Mm.
And if they are still not willing, you move to the next stage. So let's assume that we have written to them, because that's the right thing to do. So once the decision is made and you are not given any admin review or any remedy which comes with time, immediately you have to write to them and give them what we call pre-action protocol letter.
Okay.
Pre-action. If you are not told to do admin review, don't do admin review, because that is not a way to go through the arbitration.
Okay.
So where there's no admin review remedy, your arbitration process or your alternative resolution process will be pre-action protocol. What does pre-action protocol say? It says that put the person on notice that you are not happy with the decision, give your reasons why you are not happy with it, and give them opportunity to resolve it or to reconsider. So immediately we go to them. Once they receive the letter, and here we have to be careful, there is a catch here. They know that you have 90 days.
Mhm.
So once they receive the letter tomorrow or Monday, 24th, they may delay the decision for till the 9th day, the 90th day, the 90th day. So
Mhm.
you don't have to wait for them to come back to you if the clock is still ticking against you.
So
So if the clock is,
you know when you have put in the application, so then
I mean,
you count from there, and you don't
from the
have to
time
wait
you
for the
send,
90 days.
so from the time you send a pre-action protocol letter to them,
Mhm.
putting them on notice under the rules that give them alternative opportunity to
Mhm.
resolve it with you. Once you send that notice, you are telling them that I'm not happy. If you don't look into it to resolve it, these are my reasons. I will take you to court
Okay.
for judicial review. They also know that the rule says that you have 28, you have 90 days
90 days.
to
Yeah.
go to court.
Mhm.
So if today's date is 22nd, which is the date of the refusal, 90 days will be March, April, May,
May,
June
June.
22nd, isn't it?
Mhm.
90 days, give and take, there will be 31 days somewhere. Because March is 31, April is 30, May
That's
is
61
31.
days.
And therefore, give and take is going to be about 23rd, 24th of the third month, which is May. So March, April, May. Sorry, April, May, June, 90 days. So with the 90 day that you are counting to be that is going to be in June
Mhm.
or by the 23rd or 22nd of June, you don't have to wait for them to play games, because they can play game and wait and come to you with decision by the 23rd of June. That time it may be too late for you to go to court,
Mhm.
because if you go to court the next day, the court will say you are late. You had the whole 90 days. You will say that, but I was waiting for them. You told me I should do alternative resolution with them. And we
Mhm.
said, we told you to do so. But whilst they were not coming with response, you shouldn't have exhausted all the 90 days.
Okay.
So you have to count your time and know when to fire.
Okay.
So, and because they also know that they will, so either they wait or they will do the right thing. So there's a case we did. So once we send the pre-action protocol letter to them that we are not happy with the visitor's visa refusal, they came to say that we have received the pre-action protocol letter. We are looking into it. We'll come to you with decision in on the 3rd of January.
Okay.
So we know that we don't have to do anything until from the 3rd of
3rd
January.
of January.
Because if even if they don't come to us and 90 days expire and we go to court, we'll tell them that they said we should wait till January. So
So
it
in
doesn't
that
give
case,
them.
then you had a response, and there's a definite date, and saying that we will come to you by this time. So
Very good.
then in that situation, you are not counting your clock; you are counting their clock.
Very good. And and therefore the 22nd has now shifted to the 3rd of January.
Hmm.
Because they've told you that we'll give you the response by 3rd of January. So
Okay.
even though you had, or let's say 3rd of June, so even though you had from March, April, May, and June is your critical period, they've told you that will come to you even by end of June. If it's end of June, the 90 days will not count against you.
Right.
Then the 90 days will count from that time they came back to you with a response. So let's say 30th of June, they came to you with a response and they said that we are sorry, we have maintained the decision to refuse.
So then you count the
Then
90 days from there for your next level or your next action.
good. So now we have two decisions, right?
Hmm.
The original decision that is under challenge and the maintained decision.
Okay.
So the maintained decision becomes the relevant decision.
Hmm.
And if you look at Procedure Rules 28, it says that not less than 3 months from the date of decision. So in this case, the decision will not be the date of refusal, but the date they came back with their
With
what?
their own decision.
Alternative dispute response.
Okay. Right.
So
That in itself would be a bit confusing, but the clarity here is the court says that engage them.
engage
When you
them.
engage them and they give you a response and they maintain the original decision, then you are going to say that, well, you gave me a decision or you gave me a time up to X date. You have come back to me and I don't still agree with your decision that you have made. So I'm going to take the next steps. So my 90 days is counted from the date that they give me the new decision that is the relevant one at the moment. Is that how we should look at it, lawyer?
Yes. So that is how we look at this. Exactly so.
Okay.
Yes. So once we know that we have defined the critical date or the material date, we know
Mhm.
that our counting will start from there. But at the same time, we are saying that if it's going to take forever for them to come to you with response, then be mindful that if they are late to come to you with response later than the 90 days you have, you cannot use that as excuse when you go to court.
Okay. So then,
That is
if they don't, please act before the 90 days because then the court will tell you that, well, you have 90 days to do this. You have engaged them, even though you have not responded. You have sat back and wasted your own time. Well, folks, um, it's a bit of a technical discussion, so I will want you to just take a break, relax. Lawyer will come back. We'll continue from there when we have heard from the government organization here, the Home Office to be precise, the next steps we're taking, going to court, and what we do beyond that so we can get the court to reverse the decision that's been made against us. It's still the community and the law, and it's brought to you by BWF Solicitors. What they're telling us is we celebrating Ghana Month, they providing us with enough information, empowering us to know all the things we need to know as much as possible, and also celebrating Ghana as well. This afternoon, we've looked at some of the cross symbols that are used in the legal circles. And I am asking you, do you remember the one that says handcuffs? Do you remember the one that says fence? I may be asking you questions about that. So make a note of that. And also remember earlier on, I mentioned that the admin review, appendix administrative review, paragraph 4.4 is talking about when you have something pending, making a new application, and that's taking away your section 3C protection. A lot of information, a lot to learn, but take a break. We'll come back to continue.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
I've sent a new one.
Well, we are on a learning spree, and definitely the evidence and the strategies are being given us by BWF Solicitors, our trusted partners when it comes to the law. And we're doing this live on BWTV, the community, and the law is the program. My name is Oreku Frimpon, and my guest and resource person is Lawyer Charles Asma from BWF Solicitors. We are looking at how to use a judicial review to reverse a UK visa refusal. Last month, we were talking about the point where the Home Office may have responded and the next steps we need to take. Now, let's go on the journey. I think you're on mute. Can you readjust for me?
Oh, thank you so
Yes.
much. So, as we're discussing, we are looking at using judicial review to reverse a decision. So, we are quickly going to look at a case in point. Then, if they did not change mind, what would we have done? In this one, they changed their mind after our arbitration process or the alternative dispute resolution process. You know, the rules say go to them in case they will change their mind. So we
Okay.
went with our pre-action protocol letter and they changed their mind. They said they will come by June 3rd of January. They came by the 8th of January with a decision that it has been overturned because pre-action protocol challenge makes sense. So we didn't have to go further. but then we were going to go further. So I just wanted to put in context in that respect. So if producer is available, so the context is that application was made for visitors visa.
Mm-hmm.
5 people, father, mother, and 3 children, visiting their family member in the UK. They were all refused.
Okay.
Refused because they think they didn't have enough funds. And so, as it's always the case with visitors visa application, they will refuse you with any reason. We put in challenge. So first, we prepared a pre-action protocol. So what we are not going to show is the decision letter itself, and the decision is that it was refused.
Okay.
So under the procedural rules, the rules say that under part 4, under the arbitration process or the alternative dispute resolution process, it says go to them. So we had to go to them. So when did we go to them? Producer will show us when we went to them with a challenge. Because we are
Okay.
looking at how to get them to reverse the decision. So
Want to look at the pre-action protocol, isn't it?
yes, we are looking at the pre-action protocol letter, which is the
Okay.
alternative dispute resolution that the law says or the rules say we should first
We should
do.
refer them to and follow. Yeah. Okay. Can we have that? Yeah. Scroll up a bit. No, 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 no. It's not properly redacted. So scroll up. Okay. Details of the
No,
matter being challenged. You wrote to the Home
as,
Office on the
but
19th.
sorry, hold on for me. I think this is the response from them. We are looking at the pre-action protocol itself. So please, the pre-action protocol from us.
Okay, we got it. It will be up in a moment. Yes.
Okay,
Um,
right. So from the top, you just make sure that it's fully compliant with the GDR
okay.
process.
Um,
Okay,
the,
okay,
the
yes.
the names are there. So we will try and get those redacted as much
So
as
that's fine.
possible.
Continue from here. Continue, just read from here. We continue to
Okay,
act.
we continue to act for the above named applicants in relation to their immigration matter. The issue and the challenge is the SSHD's Secretary of State for Home Department's decision to refuse our clients' applications. This is therefore a notice before claim of unreasonable decision. And we've named the Secretary of State for Home Department as the defendant. There are no other interested parties. Let's see. Yes. Our clients are the direct move up, move up, move
So,
up,
so
please,
just go,
move up.
keep going, keep going, keep go to the issue. Yeah,
Yes.
the issue,
Legal
the
issues,
issue,
yes.
the legal
The
issues.
legal
Yes.
issues for consideration are unreasonable use of discretion to refuse a visit application and failure to consider the applicant's rights to family life with their sponsor. Um, we submitted that the Secretary of State for Home Department has a duty to process applications as fairly and efficiently as possible. Um, we also submitted that the refusal of the client's application without considering it substantively on its merits is unlawful, as they are family members of their sponsors. It's also submitted that clients meet the requirements under Appendix V, as they demonstrated genuine intention to visit the UK, in that they have commitments in Ghana, and that it's objective that they would return to continue their lives in Ghana as employees, adult applicants, and students, or the child applicants, respectively. Then
Okay.
submitted that their clients sufficiently demonstrated their circumstances in Ghana, in that they are of those positions in
Yeah.
respectively. Yes, Lawyer.
Okay. Scroll down. Let's see what we ask from them. So go to the remedy.
Okay, so what we are looking for, the Secretary of State
Just
should,
move out a bit. You just yeah, the remedy. Just go up. Skip yeah. Okay. So go to the remedy, but make sure there's no name showing.
yeah, that's what we're doing. Um,
Okay.
Breach of Article 8, right, scroll up, just the
No.
remedy.
Only the remedy. Only the
Just a
remedy.
remedy, scroll up. Yeah, that's it.
Yeah, that's it.
Secretary of State to withdraw his decisions and grant our clients entry clearance to UK as visitors. And we're looking to have a response as soon as possible, but in any event within the next 14 days. This is accordance with the timescales for responding to letter before claim set down in CPR 54 and pre-action protocol.
Right. And we scroll down and let me see what we have there. Okay, right. And we told them that they have 14 days to respond.
Mhm.
And we also told them where they have to serve documents, and we ended. We left it there for them. So, so this is compliance with the relevant provisions of the 2008 Upper Tribunal Procedure Rules, where it says that let them know that there's something wrong and you are not happy in case they want
Mhm.
to change their mind. So we
Right.
ticked the box, didn't we? Right.
Yes.
Then they came back. What did they come back to say? Producer, now show us the one that is redacted.
Yeah.
Okay.
No, that's enough. That's
Yeah,
enough.
yeah.
That's enough.
From the yeah, from here.
So it says details of the matter being challenged, and it says on that date we received challenging the decision to refuse your client's entry clearance application to enter the UK as a standard visa. You allege that the ECO's refusal of your client's application without considering it substantively on its merit is unlawful. Additionally, you allege the entry clearance officer does the ECO decision is perverse, unjustifiably harsh, and unreasonably falling below the standards expected of the UKBA. Finally, you allege the ECO's decision to refuse a family member's entry permit to the UK is a breach of your client's Article 8 rights. You've asked for the following relief: the reconsideration of the refusal decision dated there and grant the entry clearance to the UK. Now, what are they responding to and how are they responding to that? They've reviewed the decision to refuse the entry clearance and now proceed to reconsider the matter in the light of the representations you have made. They aim to contact you by the 3rd of January 2025 regarding the outcome of this reconsideration, absent special circumstances. Details of other interested parties were not stated, and um, has considered your request and deems that a sufficient remedy has been provided. Therefore, the pre-action protocol is now considered to be concluded. However, if you wish to proceed to judicial review, the service address for judicial review is as follows, and the rest of it.
Good. So if you go to number 4, paragraph 4, response to the matter, they give a date, right?
Yeah,
What date did they say they will come back
the
with
3rd of
response?
January 2025.
So that becomes the relevant date, not the date the visa was refused.
Mhm. So your
Because
90
they have
days will be counted from
the
there.
90 days will count from here when they come back to us.
Okay.
And if they don't come back from the 3rd of, if they don't come back by the 3rd of January 2025, then we have 3rd of February, 3rd of March, 3rd of April, 90 days to go to court.
And February this year was 28 days, isn't it?
Well, then in that case, we'll benefit from the 28 days by going two
An
more
extra
days
2 days.
extra here. But it just
Okay.
it's 90 clear days. So you just have to count the 90 days, including weekends.
Okay. Oh,
Yeah.
including weekends.
Yeah, it's 90 clear days, not
No,
working days.
no working days. Right.
So
Okay.
90 every day.
That I would want to stress should be considered as well. It's not 90 working days, but 90 clear days or 90 ordinary days. So you count Saturdays and Sundays. Would you count bank holidays?
So it says 90 clear days without exception. So yes.
Okay. All right. All right. So for instance, in this situation, they have agreed that you don't need to do any other things because they have reconsidered their decision and the pre-action protocol has ended. If they said that no, they have refused still, what was going to happen?
No, they haven't finished. Because they said that we will come back to you by the 3rd, and therefore we consider that this particular pre-action protocol letter is exhausted because we've told you that wait will come to you.
Okay.
So we had to then stop everything to wait.
And
So I
wait.
told the client, they said they will come. And the client said, no, 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 let's go to court. And I said, hang on, this is common sense. The person you are fighting says that give me some time, I'll come to you. So if you rush to go to court, What are you going to tell the court? You tell them that I'm so stubborn that I can't wait, or what? So they had to then wait. Then the 3rd of January, I said that they haven't come. So we started organizing from the 4th of January, 5th of January. Then 8th of January, they came. Producer, what did they come with?
So on the 8th of January, that is 3 clear days after the date they said they would come back, they came in, and is it this
Okay,
one?
so what does it say? Subject.
The subject says overturned resubmission.
All right. So, and it says,
You are required to submit your passport within 15 days for the they've given the
okay,
address. Okay.
all right.
An appointment is not required
Why?
to overturn resubmission because they have overturned, and they
Da,
gave
da, da,
you
da,
the
da, yeah.
opening hours and the rest of it.
Yeah. So they came to say that, you know what, we have reconsidered the thing and we think you are right. Your argument is solid and you've covered all grounds. And so we have no option than to ask them to come and get a visa. So let them bring their passport.
No, so if they came back and insisted that we stand by our decision, or yes, they came back and said we stand by our decision. They are 3 days late. They have given us an unfavorable decision. What would have been the next step?
Well, the next step is that your 90 days will start from the 3rd of January. So whether they were late or not, it's not a big deal
Okay.
because you have 90 days. And they said 3rd of January they will come. And if they had not responded by 3rd of January, we could have gone to court. But we still had 90 days to do that. So we could wait a bit.
So
So the
in
90
this
days,
case, do you necessarily have to give um, the respondent, in this case, the government agency, in this particular case, the Home Office, do you have to necessarily give them the benefit of the doubt so then you operate within the 90-day period?
benefits of the doubt in terms of what coming,
Yes, them
okay,
giving them
they
time to come back.
oh, right. Okay, I mean, yeah. So more or less, we are reinventing the wheel. First, it was when the visa was refused, so we had our 90 days from there.
Mhm.
Second, it is when they came to say that we are doing something, so wait for us up to this date. So
Okay.
the 3rd of January became the starting point, and we're still waiting for them to come back. So
Yeah.
if they had not come back and the clock was still ticking, would have just gone further. Actually, we're in the process, but then we had to wait to see because it's all about cost and all these things. So I told client that give yourself time, let's wait for them.
Okay.
But the key thing is this: so they've come back. What if they didn't come back, or they came back with negative response? Then
Mhm.
we have to go to the court, which is the upper tribunal for judicial review. So we have to make application to court. Again, we follow the rules. But for the purposes of because of time and other things, I want to take listeners and viewers through the process. So, producer, do you have the 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 platform for filing? If you check your yes, very good. So now we are going to court. So we prepare our argument, we
Mhm.
prepare our case with our evidence, and prepare a bundle. And we go to the court portal, and you have to log in to file what we call judicial review application. And here we have to bear in mind that it is not paper, so you have to go do it online. You register, you log in, and you file your document. Before filing your document, you have to prepare your argument, what we call your grounds. So the grounds, you set it out properly, because now you are going to court to fight it. You put together all the evidence and match it properly with index and all that. Then you follow the process to file it. You complete a form called UTIAC 1. UTIAC 1 is the judicial review form for upper tribunal filing. So you complete the form with the names of the parties and the matter and everything else, and you pay a court fee of £169. Do you have to pay for each of the five? No, it's a one pack. So this is one case with applicant and others. So the main person and others all together. So one case. You don't have to pay twice. You file it once. Then the home office will be notified. You also have to notify the home office that you have now filed your case with the court for judicial review. Remember, in their response, they said that if you want to do or further your judicial review, you can go ahead. Remember.
Mhm.
So this is where you go to file it. Once you have filed, you inform the home office that I have done it. Court, you have to then wait for the court to come back to you. We call it seal. Court will have to approve your, more or less accept the application. Once they accept the application to process, it's called sealed judicial review claim. Then you take it to the home office to tell them that my judicial review claim has now been sealed. That means court has received it. If court hasn't received it and or has confirmed receipt and time passes, home office will say you didn't do it within time because we didn't receive the court confirmation in time. So yours is to move quick, 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 including night. Make sure that court comes to you. And once you do that, you let them know, and that sets the litigation in motion. They will then also write to you with the next steps. They will file their necessary document and so on and so forth. And court will review both of them, and court will come back to say that the application for permission to pursue a judicial review has been accepted, in other words, granted or rejected, dismissed. So if it is not something sensible to the court or doesn't follow procedures or the case has no prospect, realistic prospect of success, the court will reject it or dismiss it. So once you are successful with it, that means court has granted permission. Then you go through the process. As I said, Home Office was able to change their mind. But if the Home Office did not change mind, then the process will travel through. Sometimes it can even get to Supreme Court as far as judicial review is concerned. And the final decision will then bind.
Well, if you probably have just joined us, we have been discussing how to use judicial review to reverse a UK visa refusal by the Home Office. Lawyer Charles Asma from BWF Solicitors is our guest, and he's taking us through the various steps why you need to use judicial review and how to use that. And he's taking through us through some legal lessons here. And if for nothing at all, remember that if you want to use judicial review in any visa refusal application or any situation where you want the courts to uh, take your stance or defend you or get to have decisions made in your favor, the decision made by a government agency, you'd have to engage them first. Well, I'm engaging you. Take a break. Look at these messages. Take the telephone numbers of BWF solicitors down. Get yourself ready to ask your questions. Put the questions to lawyer Charles Asma because he's ready to answer them. It may be about what we have discussed this afternoon or any other immigration matter that is bothering you. 0208 493 7345. Or you can send a text or WhatsApp message to 07399 208 468. 07399 208 468. Don't go anywhere. We'll be right back.
Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and ready for your questions and your concerns. Keep them in the comment section down below, either on Facebook at BWF Solicitors, at BWTV, and on YouTube at BWF Solicitors and at BWTV. This afternoon, we've been discussing how to use judicial review to reverse a visa refusal by the UK government, or the Home Office, so to speak. Lawyer Charles Osman from BWF Solicitors has been taking us through the steps. So, yes, the lines are active: 0208493745, or send a text or WhatsApp to 07399208468, or you can leave them in the comment section down below. Lawyer Osman, um, judicial review. It looks like, yes, you're going very high up the legal um, ladder, if I can say that. It must be very expensive, I guess, and people may not want to dare go there. Well, I'm a visitor. You're not asking, or you're not allowing me to come into your country. And probably I'm coming even for an event that will happen within 3 months of the dates that I put in the application. Why should I bother myself?
Right. The rules say that you do not pursue judicial review simply because you are not happy with the decision,
Hmm.
or simply because the decision is wrong. You pursue because the decision is unlawful.
Okay.
If it is unlawful, then it doesn't really matter what my visit was about. You haven't done your job properly.
Okay.
So in this instance, in our client case, this is somebody visiting the family, a brother visiting a brother with his family,
Hmm.
wife and children, visiting the brother in the UK. And they said, you don't have enough funds, and therefore we don't think you are a genuine visitor. And our argument is that saying that he's not a genuine visitor is not fair, because this is somebody who has even visited the UK before. This is somebody who has a lot to do in their country. This is somebody who has a family. And are you saying that family members cannot visit their family members? That is harsh.
Mm.
And it appears that you have arbitrarily applied the rules to favor yourself. And so we put in a challenge.
Okay.
So,
Yeah.
yeah,
Sorry. Go on.
no, yeah, that's it.
Well, somebody is asking a very interesting question here. I'll put it in the chat and let's see what response we can get. It's talking about cost, how much it's going to cost to do the challenge and the review.
Right.
Yeah, it hasn't come
So,
through. I'll put it in there 1 second. Yes, Lawyer.
so we have the application. So we have court fee and the legal fee.
Mm-hmm.
So I will take you through the court fees, which are some are standard, and the legal fees, which are based on the legal person dealing with the matter.
Okay.
So the legal fee at up to upper tribunal, the court fee. So initial application is 169 per application.
Mm-hmm.
Then once the application is granted, your application to pursue judicial review is granted, you have to pay 840 something. I'm not quite up to the last penny, but it's about 840 something pounds. Let's say 850 pounds you pay once it's granted for you to move to the next level. And every level it travels to, you have to pay a particular fee. So let's assume that by the time you finish the process, court fee alone would have been about, say, 3,000 pounds. Example, this is just example. Then you come to the legal fee. The solicitor will have to charge you to do the job. In some instances, barristers will have to be involved. And so let's assume that the entire legal fee may come up to the end. Let's say again simplistic, 6,000. Six plus the court fee of about three, making 9,000. So even if you are spending average of 5,000, 6,000 pounds, inclusive of everything, again, barrister fee comes in. So inclusive of everything, let's say 6 or 5, then that is so much, but it can even be more than that.
Mm.
So I cannot say that it costs X amount, but I can tell you that the court fee is 169 to start, and the next is 850, and so on and so forth. So the question is, what happens if I win?
Mm-hmm.
The rules say that once you win the judicial review, the Secretary of State, which is the losing party, must pay your cost. And they say reasonable cost. So if you spend about 8,000 to pursue the claim, then they have to pay all the 8,000. If they think all the 8,000 is not reasonable, then it becomes a negotiation. What is reasonable?
Does it happen at all? Do they pay back
In terms of, oh
when
yes, that's
they
one I'm
they do
that's one
not
I'm
win?
pursuing at the moment. If you what?
If they do not win, and you
The
want
client
to claim reasonable costs from,
the
do
client
they
the client
pay?
has no win, or Home Office does
No, the
not
Home
win.
Office does not win. That's what I mean.
Okay, then say what how much what does the client get if the client wins? Because for me, I'm interested in the client, not the Home
Yes, if the
Office.
client wins, how much does the client get?
So the rule said a reasonable cost of whatever they have incurred.
Mm-hmm.
So if I really want to fight, I would say that, you know what, reasonable is everything spent on this matter because you caused it.
Yeah.
So if my client spent, let's say, 8,000 pounds, I can fight to claim all the 8,000 pounds. But if my client says they spent, or for example, there's other incidentals which are not really actuals. For example, my client will say, because of your decision, I lost my ticket money. I bought tickets and I couldn't travel and blah blah blah. I can't get a refund from there. Those ones will not be reasonable cost to be refunded.
Okay. And who determines the reasonableness? Is it the court, or it will be negotiations between the two legal teams, the Home Office and the client side?
Yes, the two legal teams. So the Home Office, if they are deciding to, that's the case where they have written to us to come to the table for a conversation so that we don't continue because they know they will lose. So what they've asked for is for us to do what we call a consent order. So once we agree that our client is not pursuing anymore, we agreed how much is reasonable cost per what the client has spent. Then they will prepare a consent order, agreement order. Then they will go to court and tell the court that we have agreed not to fight the case, and rather give the visa to the client or give whatever it is to the client, to the applicant or
Mm.
the claimant. And so this is the order we have prepared in terms of agreement or consent, court will then seal it to become an order or judgment. And the court will say, per the consent between the parties of this date, wherein they agreed XYZ, court is hereby that it is ordered that blah 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 blah, and the other side pays reasonable cost to this side. By which time we've agreed what reasonable cost it is, and the court will enter it as part of the judgment. Then they will prepare a check to send to our client.
Oh, okay. Yeah, if you have any question, we'll pick them from the comment section down below, or you can send in a text. We move on. Remember, I have the question and a scenario I want answers to from you. So let's see what we have. If there are any on there. Obapa Grace, hi. Can you apply for naturalization if you have CCJ? Well,
Um, I mean, CCJs do not adversely affect naturalization applications. I mean, a lot of people experience CCJs, especially when the CCJ is satisfied. Even if it is not satisfied, it might not be a case for suitability. It could even be person had a penalty fine, driving fine, and they forgot about it, and it went up, and they entered as judgment against them, or anything. Sometimes CCJ can be as low as £1 up to whatever. So CCJ, of course, if you owe £1, you don't pay, the person pursues it. It goes to county court at Northampton, and it is
but
entered
that court,
against.
do they open at all?
Oh yeah, they operate.
Because
Yes, and
you would call them over and they won't even respond.
yeah, you call them when you have time. So what happens is that normally when you have time, when you do that, you call them, leave it on loudspeaker, and do whatever you are doing. After 1 hour, 2 hours, 3 hours, somebody will pick. But you don't call them expecting for them to quickly pick and talk to you so that you continue what you are doing. So I always tell people that when you are calling these people, make
Make
sure
sure you
that
have time.
you have time. So you are at home, do your own thing, or even if you are at work, then you put it and it will be running, ringing, waiting. Then that's fine. But they do operate and they respond to calls. Yeah.
Well, I maybe you're the only person telling me they respond because I know people complain that that call doesn't even respond. Anyway, well, whatever it is, try your luck. You have time to do that. Let's see what next we have, and then we will move on. Is live on BWTV, and the community and the law is the program. Please, I got my 2.5 years on 2015 in September. My last one is finishing 2027. Can I apply for indefinite leave to remain in September?
Oh, so, hold on again. I got my 2.5, 2015. My last one finishing 2027. Can I apply for indefinite? So we have to count 2015 to 2025 September. Yes. So provided there's no break, the reason why this is 2027 is that it took some time for Home Office to make decisions for some of the applications. And that's why it's gone more than 10 years. And so when you are due by the September 2025, you can apply, provided there was no break. Because we know the case of Iyaki, and we know the case of Afzal, which says that if there is a break because you delayed in making a renewal application and also delayed at the Home Office, it will go against you.
Okay, right. I think we have time for one more question. Say yes. That's your answer. Lawyers giving you. We can have one more and run out. We're running out of time. So, um, Kofi, who's on a student visa, applied for an extension a month ago before his visa expired and is still waiting for a decision. I think it must be a follow up to some previous question. Citizen Kwadwo, if there's anything, please um, get us some clarification. But yes, I mentioned to you that I have a scenario with my friend Kofi Kenata. It's an imaginary name, so don't mind me. And what I asked was that Kofi makes an application to remain as a spouse undergraduate route. The application was refused because the Home Office suspected the marriage was not genuine. He applied for administrative review on a caseworker or casework error. Whilst waiting for a decision on the administrative review, Kofi receives a certificate of sponsorship from a healthcare company. So the question I'm asking you is, can Kofi make a switch to the certificate of sponsorship? I have three options. One, yes, because he's still living in the UK legally and Section 3C protects him. No, because any fresh application will bring the Section 3C protection to an end. And three, no, because the Home Office suspects his marriage is a sham. Think about it. I'll come for your answers in a minute. Well, I am expecting your answers, but before then, let's take this question. Um, Bobby says, I am a British citizen, I have Ghanaian passport. Can I apply for e-visa in my indefinite level to remain? Indefinite leave, I guess that's what you want to say. Right. The person is a dual national and want to find out if he has to get an e-visa account. You're mute, lawyer.
E-visa is for those who have leave to remain, i.e., limited leave or indefinite leave. They are foreigners. So this person is a British citizen. There's no restriction.
Okay. Well, lawyer, let me go to the classroom again and find out what answers people have given me. Then I will come to you for the correct one. Kofi Kinata's scenario. Let's see. What answers do you have for me? Um, Kezia says is yes, because he's still living in the UK legally and Section 3C protects him. Well, Kezia, thank you. Next one, Anna says number 2, no, because any fresh application will bring the Section 3C protection to an end. Nana Yanketia thinks the answer is number 2. Thank you. Next one is from Nanansu, says number 3, no, because the Home Office suspects his marriage is a sham. Kofi Kenyatta makes an application to remain as a spouse on the graduate route, gets a CO as wants to switch after he's made the administrative review application. Benjamin Boas thinks it's number 3, not because the Home Office suspects his marriage is a sham. Ben, thank you. Johnny Ampon Sim says number 1, he's still living in the UK legally, and Section 3C protects him. Emmanuel thinks so as well, number 1. Thank you, Emmanuel. Dunn Kwame thinks number 2, no, because any fresh application will bring Section 3C protection to an end. Cosmis Mensa, number 2, as I just read. Thank you, Cosmis. Next one is Tilly Duma, thinks it's number 2. Tilly, thank you for staying with us on Facebook. We have Hannah Ridu, thinks it's number 1. Hannah, thank you. It's number 1. Well, Leah will tell us if it's true or not. Samuel Malfo says number 1. Let's see. Paula Say says number 2. Let me take just a couple more and I'll go to lawyer for the lack of time. Maybe Sousu says number 3. No, because the Home Office suspects marriage is a sham. Kwame Adu also thinks it's number 3. And with that, let's go to lawyer Charles Asma. Kofi Kenata's situation. He makes an application to remain as a spouse on the graduate route. Was refused because the Home Office suspects the marriage was not genuine. He applies for administrative review on casework error. Whilst he's waiting, fortunately, he gets a certificate of sponsorship and he thinks, well, let me switch. I've got something that can give me 2 feet to stand on. What's going to happen? Lawyer.
Right. So the rules are clear under paragraph AR 4.4 of the administrative appendix administrative review, which says that once you have administrative review ongoing, no matter what, wait till it is over. if you want your right to be protected.
Mm.
So this person had right undergraduate route visa. Is that what it is? Okay, as a spouse. So
As a
the
spouse.
application was refused. Yeah.
Hmm.
So this person applied under the graduate route and the application was refused. What it means is that before the graduate route, they had student visa, which was valid. They switched to graduate and the graduate was refused. So they protect and they pursued admin review. The protection was there. They decided not to wait, but put in another application, fresh application, because they now have COS. And the moment they put in the application, the administrative review challenge ends. At the time they put in the COS application or the skilled worker application, did they have visa? The answer is no, because at that time they were pursuing admin review and they didn't wait. And so, unfortunately, Kofi will have nothing. And so protection will be cut short. So, no.
So lawyer says no, because if you put in any fresh application, you've genuinely told them my application is no more needed, it is not available. When a person has pending administrative review and makes a new application for entry, clearance, or permission to enter or stay the administrative review, is treated as withdrawn the day before the new application was made. Always speak to a qualified lawyer before you make a fresh application in any situation, especially when you are working under the Appendix Administrative Review AR 4.4. Leasma, with your kind permission, what did we look at this afternoon?
Thank you very much. Today we looked at how to get a visa reversed, visa refusal reversed using judicial review. We understood that if you have no remedy open to you, i.e., appeal or administrative review, judicial review is available, provided the decision was made by a public body. Visa decision is always by a public body, and therefore judicial review is available when you are refused. When you are refused, check, do I have administrative review right? If no, do I have appeal right? If no, then judicial review. There's one point where there will be no remedy, that is visitor's visa application, and that automatically you have to pursue the judicial review. We understood that the rule book is the procedural rule for upper tribunal 2008, and we understood that section or the part that deals with application says that you have to bring the application within 3 months of the decision. It also says that you have to make sure that you let the decision maker know that you are not happy. And therefore, the timing is important. Once you have not submitted within the 90 days, and 90 days is over, you have forfeited your chance. The court will not entertain it unless you have reason for lateness. It is expensive because the court fee is 169. There will be legal fees if you are using a lawyer. You can do it yourself, but you have to use the online e-filing system. You have to use the relevant form, UTIAC 1, which is the judicial review application form. You have to make sure that you tick all the boxes to get it right. Otherwise, any lapse within the process will render the whole application invalid, and that will mean you do not have any further remedy. Once you succeed, Home Office will pay your cost. Once you lose, you have to pay Home Office cost. And so before you decide to do this, make sure that you have realistic prospect of success. Otherwise, don't. This is what we've covered, that it is possible to have your refusal decision reversed once you are clear that judicial review will be appropriate because the decision is unlawful or procedurally incorrect. This is the conversation for today. Thank you.
Thank you, Lawyer Charles Asma. And that brings us to the point where we're drawing the curtains down on today's edition of the Community and the Law, brought to you by BWF Solicitors. And as Lawyer said, we looked at how to use a judicial review to reverse a UK visa refusal. And we're doing this within Ghana Month. We showed you some of the Adinkra symbols that have been used or are being used within the legal circles. Same time next week, we'll be bringing you other bits, and we will be educating you on the country Ghana as well. And then we also bring you another topic for discussion. So I believe you want to make a date and sit with us for the 2 hours between 4 and 6 p.m. UK time. Let us Asma, thank you so very much. And to BWF solicitors, we say thank you very much for the opportunity you give us every week. And to the family BWF solicitors, all the workers, case workers, front desk admins, the lawyers, and everybody for the uh, research and the support you give us. To Sheila and Kram Padmododu for the aesthetics and the admin work. And to my indefatigable producer, Professor Ade, thank you to all of you. My name is Oreku Frimpon. Have a wonderful week and make sure you come back. We have another edition in waiting. Good evening.